We've been talking to Chris Daw, who's a QC, that stands for Queen's Counsel. He's as a Queen's Counsel, you're one of the most senior barristers. He's a criminal defence lawyer representing lots of interesting people. And he's written a book called Justice on Trial, Radical Solutions for a System at Breaking Point. And we started talking to him about tips for appearances in court if you're in the criminal court or the family court, and he's got lots of interesting tips for that. And then we went on to speak about his book and one particular aspect of his book, which is the criminalisation of children. Chris, we hear from quite a lot of litigants in person who are struggling in the court system, not particularly in the criminal system, but in the family court. But they are also coming into contact with the criminal system because sometimes allegations are being made about them in terms of the relationship. Many are saying they're false allegations. Many are saying that they're really out of their depth and they can't afford to get a lawyer. Any tips that might help anyone who's in court on their own?
I think most sort of reasonably intelligent and reasonably articulate and literate people can navigate through the system. And I think my kind of primary piece of advice for people in that situation is that, and it's a really, really hard thing to do when you're in the middle of the situation, is that you have to find a way to remove your own emotions from your analysis of the process. Because one of the things I think that's most dangerous for litigants in person is when they won't apply reason, objectivity and judgment, and they simply want what they want because they believe they should have it. And they have a deeply often emotional, almost a sort of visceral response to anyone who disagrees with them about anything, whether that be the judge, whether that be potentially a lawyer if there's a lawyer on the other side. Of course, whether it be in a family law situation, it might be their partner or former partner. They just automatically and reflexively disagree with the other side and just want to do the opposite of what the other side says or anyone that disagrees with it. So I think one of the tips I would give to anyone who's going through a court process and doesn't have the wherewithal or the financial resources rather to employ a professional is that they should really try and find a trusted friend who's sensible to talk to about it and to help them through the process. Of course, I know these things are very sensitive and often there's lots of personal information sort of floating around, particularly in a family law case. But hopefully most people have someone they can trust. It might be a relative, it might just be a close friend. It might be, who knows, someone at work that they have a strong relationship that they trust. But find someone so that you're not on your own, if at all possible. Because I think just having someone else, and tell that person that you want them to tell the truth and to be objective.
Yeah.
So it's no good having someone that you will just want as an echo chamber for your own opinion, and who you don't encourage to try and perhaps give you advice that you're looking at things the wrong way or you're being too emotional. You need someone who's going to be objective, who's perhaps going to, not in a professional sense but in a personal sense, take on that role of being objective. That's really, really important. So I think if you're able to do that, that's a help because you won't feel that you're all on your own, which I think is one of the hardest things for litigants in person, particularly in the family courts. But then when it comes to actually dealing with the case, I think it's really important to understand that the legal process is a system of rules and they're written down. Now, that can be quite frightening because as anyone who's ever been in a law library or if anyone looks up a picture of a law library will realise that they are very large places full of many, many books. Increasingly nowadays we access all of that information through online resources, but law is written down and it's voluminous. But that said, most cases revolve around a relatively small set of legal rules and a relatively small set of procedures. So one of the things that I would, again, advise people to do is find out what the rules are. Most of it's available online. Much of it certainly is available online. For example, the civil procedure rules and the family court rules that set out the time limits, for example, when you have to do things. And in most cases, actually give a template or a format in which documents have to be prepared and a very specific set of information that's required. In divorce proceedings, you have, for example, what's called a Form E, which is a the financial disclosure form. And all of these things are available for free online.
Yeah.
So I think it's really, really important if people are going into a process of any legal process of any kind to actually take the time to sit down and look up the rules. Make sure that you get the most recent edition, because unfortunately many people make the mistake of not realising that things like the civil procedure rules are updated every year or so, and sometimes there are updates to the practice directions, which is another sort of supplementary set of rules and that apply to civil proceedings or indeed criminal proceedings. So make sure you've got the most recent one. Look at whether the best thing to do, for example, you're looking up civil procedure rules, is look up civil procedure rules 2021, because that way you're much more likely to see the most recent one than rather the one of the ones that's now out of date, which may send you off on completely the wrong track. Because, of course, something significant may have changed in the latest revision. And whether you're a litigant in person or not, you're going to have to follow and stick to the rules. If you miss a time limit, it could be fatal to your case.
Yeah.
So find out whether there are time limits. Find out the basics like this, which a lawyer immediately, when we're looking at a legal problem, we're looking at, we're analysing it by a fixed set of rules. And we are looking at the law that applies to the particular legal issue. So, the rights and wrongs, if you like, and your rights as an individual and the obligations of the other side. So that's the sort of overview. But we're also looking at the process. And as I say, the process is something that's also written down. So I think there's no substitute for just spending a bit of time to do some research, to look into the legal problem, Google it. But whatever you do, don't trust any sources of information that are not official. Because unfortunately, when you go on so for example, Wikipedia explanations of the law, that's not an official source of law, and anyone can edit it, as everybody probably knows. So there is no legal value to you in doing your legal research on Wikipedia. You have to trust only really official sources. So government websites, which will contain all of the official criminal procedure or civil procedure rules and all of that stuff. So trust the official sources. Be very reluctant to trust unofficial sources, and certainly don't get your law from Facebook or anywhere like that, because there are many campaigners out there, unfortunately, who kind of have a very slanted perspective on a particular issue, including around the area of children and the rights and wrongs of disputes between parents about childcare and the rights in respect of children and access arrangements and so on. And unfortunately, if you end up on one of those websites, you can end up with a completely distorted picture of what the law is, or indeed what's realistic and what's achievable. But of course, the other thing I would advise is, look for free sources of information and advice. You have got Citizens Advice Bureau, you have got, there are law centres still around in some parts of the country, and there are indeed some of those that operate online or via remote systems. And there are free representation units, for example, available via various legal organisations. The Inns of Court have them. Some of the major law schools have them. So, don't spend a couple of hours researching, and you'll find you may end up with 15 or 20 options to get some sort of qualified or at least some sort of experienced legal help, from whether it be from law students or newly qualified lawyers, or in some cases, fully qualified lawyers. So find other help. So the most important lesson of all, really, is to try to step back from it and analyse the situation as if it's a problem to be solved, rather than an emotion that you need to go on a journey to try and prove a point. Because if you approach it in an emotional point proving kind of way, the chances are you'll come a cropper at some point, and you won't attract yourself to the court or the judge. Check documents, make sure you don't have spelling mistakes, structure things in a neat and clear and concise way. Do not overburden the court with too much information. Focus on what the point of the exercise is, rather than just whatever you want to say.
Well, that was actually leads nicely on to what I was going to say to you next, which is a lot of people say, I didn't feel as though I got heard. I was not listened to by the judge. And you think, you're not there, you don't know how it went. But how do you get the attention of the judge? What is the best way of approaching the judge, do you think?
The best way of approaching the judge is to be honest, open and calm. So getting emotional or angry, particularly towards the judge, is going to be unhelpful. because the judges are not used to that. They are, well, perhaps in some courts they are used to that, but they're not used to that as a means of advancing usefully a legal argument. What they want is a really clear, straightforward, honest and structured application, if you're making an oral application or indeed a written application. They want something which deals with the specific issue in hand and doesn't go off on tangents into areas that have got nothing to do with the hearing. So if you've got a hearing that's purely about, for example, some financial issue in a case, don't start talking about the fact that your ex-wife was an adulteress and had 17 affairs and really it's so unfair because of X, Y, and Z. That's not going to endear you to the judge, because the judge is going to have to repeatedly tell you to stop talking about that because it's not relevant and it's not helpful. And of course, it's likely to cause antagonism with the other side as well, whether they're represented or not. So sticking clearly to the point, which goes back to my previous kind of advice, which was find out, what is the point process? Yeah. What is the point? What is the law that applies? And what powers does the judge have? Because it's no good asking the judge to do things that he or she doesn't have the power to do. I want you to order that he can't come anywhere near my house. Well, if that's not in the application, that's not part of the proceedings you're in, the judge won't have the power to do the thing you're asking. One other thing I think is really important, because judges do try nowadays, and perhaps more so than ever, to try and help litigants in person where they're aware that someone may have a difficulty and is unrepresented, is to just be very honest and say to the judge, Your Honour, I'm really sorry. I'm very nervous. I'm really going to try my best. It really helped me if you could tell me the most important information for you, so that will help you make the decision. And I don't want to talk about things that are going to be unhelpful and waste your time. Just being honest and open with the judge and say, I don't have a lot of legal experience. I've looked into it, and as far as I'm concerned, this is what I think is important today, and this is what I'd like to achieve. I don't know if that's possible, and I really would appreciate some guidance on it. Be honest with the judge about what you don't know, and rather than lecturing the judge about what you want and what you think is important. And when the judge says, look, I'm very sorry, but under the rules we can't do that, it's no good saying to us, well, the rules are stupid, or well, they need to change them because this is outrageous, it's disgusting, etc., etc. The more you can strip away that kind of emotive language and criticism of people in a sort of very personalised way, the more likely you are to get the judge's ear. And getting the judge's ear is what we as experienced advocates are all about when it comes to proceedings that don't involve a jury, of course, in which case we're looking at things in a different way. But when I'm in court, as I was yesterday with a judge and I was making an application, my aim is to focus the judge on my agenda, and I want to do that in a way that essentially leads the judge to have some sympathy with the direction of travel that I want him to go in. If I say to the judge, look, this court is really badly run, you're clearly not listening properly to what I'm saying, the chances of me winning are going to slip away to almost zero. And when you hear me say...
Even if you've got a good case, presumably.
Even if you've got a good case, and this is the problem. With the best will in the world, judges are human, and that if they are put off by the hostility of one of the parties... I've seen it happen with professional advocates, and I've seen it happen in the Court of Appeal. Very, very senior judges, very senior lawyers, where the Court of Appeal are clearly irritated by the advocate's manner and perhaps being a bit dismissive or a bit kind of unwilling to kind of listen to a point that's being made and focusing really only on wanting to speak rather than listen. If you think about all walks of life, whenever you have a conversation with somebody and they're not really listening to you, they just want to talk at you, then that's not the sort of person who's likely to persuade you or to whom you're going to have really positive...
Well, you switch off, don't you?
And judges are the same. So if someone's lecturing them or hectoring them or telling them that they've got everything wrong and they need to get a grip, etc., it's not going to work. So just calmness, clarity, strip the emotion out, you will get a lot further than if you take it into a different direction.
And finally, on this kind of topic, the importance of evidence. What's evidence?
Well, this is another important thing. I think people need to understand the difference in an opinion or something that comes via hearsay, for example, whether that be second, third or fourth hand, something that you've read on the internet, something you've heard down the pub about what should happen about these things, or something someone told you. evidence takes really a number of forms, but the principal, most important forms of evidence are witness evidence. So that's evidence that's in the form of a witness statement, which has got a statement of truth, which is quite formal, which is indicating that the author of the statement could be prosecuted if they lie in that statement to a court. But it's really important that even whatever the form of evidence, that it's factual. So what judges are interested in when it comes to evidence, they want a witness statement that sets out the facts. They don't want to hear X is a horrible person. They don't want to hear lots and lots of descriptive stuff. They want to hear that, at 4:00 on Wednesday, he failed to pick up my daughter from school. She was left without, and so that's a factual scenario that's relevant potentially to the proceeding. Now, one of the other things that's really, really important and is evidence are contemporaneous notes. It is absolutely crucial, whatever the nature of the proceedings that you're involved in, where there is an ongoing history or an issue, as there often is in family and childcare disputes, for example, is that you keep clear records of what's happened. Now, that can be by writing them in a notebook, which you time and date, because if you don't time and date them, no one's going to accept that they were contemporaneous, and the allegation might be made that they were fabricated after the event, which sadly sometimes happens in legal proceedings. So keeping a sort of chronological record of events in one place, it can be on a computer, it can be written in a book, but where it's time, where you're keeping a record of dates and times, that's evidence. Those are records of facts that were made at the time they happened. But looking backwards and just saying, well, I think X happened 8 months ago, it's going to end up in the realms of speculation. It's not going to have much quality as evidence. So good record keeping of events, and particularly areas that are contentious, often around the arrangements with children or behaviour towards children, that's really, really important for any form of proceeding, but family law proceedings in particular. But keep those factual in nature. No swearing in them. No, it's just got to be very factual.
Well, unless somebody has sworn at someone,
quoted speech.
Absolutely.
Quoted speech. Someone's called you and this, that, and the other. Then yes, at 3:00 on Wednesday, he came to the house, shouted up at me, or 3:00 in the morning, or whatever it was, shouted the following, and then you put it in quotation marks. You've got a record. If you're being harassed or something, keep a record of the detail. It may include swearing, but it's direct reported speech.
Yes,
that's absolutely fine. And in fact, I think most people are amazed when they come to courts just how much swearing there is in court, because so many cases are very emotional and people were, swearing at each other, and the judge has to hear the evidence, as it happened. So you've got things like records and notes. You've got things obviously like nowadays, your mobile phone and your email traffic is a source of evidence. So and often one of the most important ones. So if people are texting their partner about childcare arrangements and so on, or disputes to do with money or whatever it was, then those records they have the value, of course, of being electronically time-stamped and can't really be tampered with. So if I send a text now, and someone looks at my phone, I can't make it look like that text was sent 3 months ago. That's impossible to do because that's not the way that mobile phones work. So mobile phones, email accounts, and it's really important, therefore, to keep those things. So particularly where disputes are going on for several years, make sure that you don't lose access to an email account and that you could never get into it again. So one of the important things is never really, for personal matters, never use work email. Because, if you leave work, then you won't have access to it anymore, probably. And so it's all gone. So for personal stuff, keep it on a personal email account, which you will have forever. Don't use your work email account for anything personal. Apart from anything, it's not confidential if you're using a work email account. It can be looked at by your employer. So, because they have a right to look at all of their employees' emails within certain limits. But so emails, text messages, photographs obviously are important forms of evidence. CCTV and video material can be important forms of evidence. But what one thing that's not in evidence, unless you're an expert witness, is your opinion of events. So I think most people think that their opinion is the thing that matters. Actually, it's rarely your opinion that matters. What matters is your ability to clearly narrate the facts of what has happened to you in certain situations, particularly those situations which are very important to the litigation. But the more you have contemporaneous record keeping, either by computer, handwritten notes, phones, etc., and the more you keep all of that material in one place, or ideally on one folder on a computer or in one location, always backed up, because once again, the number of times I have people in very complex and serious cases saying, I just can't get that email traffic from
Yeah.
2 or 3 years ago anymore. So just preserve records and keep them in order, because one of the things when you're talking about presenting material evidence of different kinds to judges is the last thing they want is a big random bundle of unorganized stuff.
Yeah.
Keep everything in simple, chronological or thematic order and have indexes and page numbers for everything. But I think this is the simple point. It applies to all evidence in all cases. Is just make sure you keep it and make sure you don't tamper with it, because even someone who has relatively innocent motives, if they suddenly go around deleting a load of messages, now they may be recovered anyway by the digital forensics team at the police. But
and then that looks 100% worse, doesn't it, when you've done that?
It looks 100% worse. A jury looking at it says, well, what other reason would someone be deleting their messages for?
Yeah. Now, I'm going to have to ask this. Liam Allen. Do you remember the Liam Allen case?
Yes, I met Liam. I interviewed Liam for my television series, yeah.
Okay. What would you say to boys, young men, people dating? I mean, he didn't have his phone. The relationship with the woman ended. He didn't have his phone. He had a new phone. It was the police that ended up with the only records, and the prosecution, until the third day of the trial, didn't release that information, or the majority of it wasn't released. Any advice now to anyone involved in those kind of circumstances? Do they keep records of everything?
I advise young people all the time. Generally, I have to say young men, but also young women who are victims of sexual violence and other forms of domestic violence. The truth of it is, I mean, as I say, I met Liam Allen and spoke to him at some length, and his case was, I'm afraid, it was a perfect storm of everything that's wrong with our criminal justice system. Resource issues, disclosure issues. I have to say, in that case, I don't sense that there was any deliberate withholding of information in that case. What happened was that just nobody looked at it properly, and the system, I'm afraid, is not made to work in an efficient way anymore. There is just not the resources in the system, at prosecution, within the police, within the court system, and often in the defence, although plainly his defence were quite diligent in that case, and finally at last managed to get hold of this of the key telephone evidence that showed that the sexual encounter with which he had been charged with a rape had in fact been consensual, and that was fully revealed by the complainant's messaging. But the answer to your question, in terms of as a young person or even a not so young person out there in the world, knowing that allegations of this kind can be made, is think carefully about what you write. As what particularly, I know a lot of people, young people in particular, are in the habit of continually sending messages when they're heavily intoxicated. Well, that can be deeply unwise, because those messages will come to be looked at in a very different light if the case ever ends up in court for one reason or another. Think carefully about whether you really want to be texting people when you have no real control of what you're saying. But I think, in terms of sort of sexual behaviour and sexual encounters, I just think that the primary focus for me has got to be on ensuring that there is full consent. But and that means being very conscious of the fact that one or other of the parties, it has to be said, legally speaking, generally the woman, may be too intoxicated to consent to sexual activity. Yeah. And so, and I'm afraid I've done too many cases, one is too many, but there are so many cases of young men who got very intoxicated, and a young woman who got very intoxicated, and the woman was incapable of consent. The young man was, extremely drunk as well. And the next day, when everyone's sobered up, the woman says, I just wasn't capable of consenting to that. And legally speaking, that makes him a rapist. So, be just very, very conscious of consent issues. And I think principally this is a message that has to go out to young men, because I think the responsibility lies with them to ensure that any sexual activity they engage in is fully consensual. So
and in your experience, Chris, kind of length of term if you get found to be a rapist?
Well, the kind of standard for a sort of so-called consent rape, where there's no sort of violence, and there's no, in the sense of direct physical coercion, or serious violence, and so on. You're talking about at least a sort of 5-6 year sentence, even for someone who's never been in trouble before. And if there are anything else aggravating about it, it could be significantly longer, and indeed can go well over 10-year sentences. So it's a very, very serious offence. Even lower level sexual offending, non-penetrative offending, and so on, still significant risk of a prison sentence. So I think any young man in particular who's out there, and young people have sex, obviously, as they always have done, just needs to be absolutely and acutely conscious of the need to respect consent and boundaries. And there are a number of videos, and I may have seen the T consent video, which is a brilliant kind of short video that illustrates what consent looks like and what it doesn't. And I know that young people are given education about this in schools. And my own kids have gone through it, and so but I just think that's the primary issue, rather than thinking about sort of record keeping and so on. But if an allegation is made against you, or if you've been in a situation where something's happened to you, then of course it's really important to keep hold of any communications around the time of the events, in particular, or between the two parties, because they are likely, in most cases, to end up, the most important evidence of all will be the messaging, by not just necessarily between the two, but the messages that they send to others. So if you have a young man who has been accused of rape and says, no, it was definitely consensual, and then he has sent a message 5 minutes after he left the place where it happened saying, oh, she was so drunk she didn't know what she was doing, well, that's going to be really important evidence against him. Likewise, she could be sending messages saying, I had a fantastic time, which was kind of more the Liam Allen case, where she had claimed that it was entirely non-consensual, but actually there were messages that showed that she had told other people something very different very shortly afterwards. So that's going to be really, really important evidence. The wise thing, of course, to do is not to send, not to commit acts of sexual violence in the first place. But certainly, tampering with phone evidence after the event, particularly if you know that the police are involved, is always going to end up a very serious thing, and something which could end up costing you, the case, even if actually on the merits and the rights and wrongs, you may not be guilty. But
so your book. You have the paperback. I can't even think. New paperback. Yes, it's coming out.
The delicious smell.
You've had the Kindle one. I have a lovely, and indeed, if you would like to nominate one of your listeners to receive one of these, of course, I'd be more than happy to sign it and send it to them.
How lovely!
Think of a good reason why one of your listeners, or they might want to email you with why they deserve it. So even if they just have a young person in their family who's interested in a legal career, and you never know, and having a book might be a nice thing to do. So I'm happy to send a signed copy to someone. You to tell me who you'd like it to go to. But anyway, Justice on Trial.
And the paperback is 8th of July. Brilliant. Mm-hmm. Now, there's lots of interesting stuff in it, and you've been interviewed lots of times about your view on prisons and your view on drugs, and very interesting they all are. You haven't spoken so much, though, about children and the criminalisation of children, and that would be something I'd really like to just cover with you, because having been a solicitor representing children in care proceedings and very interested in all that happens to children, the very idea of having somebody aged 11 dealt with like they're an adult, which is possible, isn't it? They can end up
10, in fact, is the minimum
10,
age,
absolutely, yeah. And you in the book talk about Boy W, a case that you were involved in. Just a little bit of background to that for the viewers.
Yeah, that was a really tragic case where there was an allegation of sexual violence, in fact rape, by a very young boy. I think he was about 5 or 6 years old, against members of the family who were themselves young children. And I was instructed to act for Boy W, as he was known, in the proceedings. Who was charged with rape and had been prosecuted and sent to the Crown Court, which is where jury trials take place, where the barristers, where we wear our wigs and our gowns, and essentially exactly the same sort of proceedings as in a murder trial for an adult. And so I was instructing the case after it had been sent to the Crown Court from the Youth Court, which is where children are normally dealt with for most criminal offences. And immediately I met this boy and realised that he had significant issues. There was in his case very little evidence, in fact, of him personally doing anything wrong. And I just felt that this was a classic example of where we as a society have gone wrong in our approach to children who come into contact with the police through criminal type allegations. And so, I mean, as it happened, that case is only really in the book because it's an example of just so many others that go wrong, where children end up being prosecuted and given criminal convictions and so on. Now, what happened in that case, as I explain in the book, is that we looked at whether he was lawfully before the Crown Court, or whether, in fact, there'd been a breach of procedure in the Youth Court, which had sent him there. And I looked at the records and realised that actually the district judge who had made the decision to send him to the Crown Court hadn't looked at the case properly and hadn't even indeed analysed the facts of the case against my individual clients at all. Had just taken the view that because there was another child involved, was involved allegedly in quite serious sexual violence, including rape directly, that they had taken the view that both of them should go up to the Crown Court for trial. And eventually we judicially reviewed that decision and managed to keep my client out of the Crown Court, save for a single appearance there. And in the end, the sending to the Crown Court was quashed on a judicial review because of that procedural irregularity, and therefore the Crown Court proceedings became a nullity. And ultimately, the CPS decided not to pursue criminal charges at all because the boy was in the care of social workers by that stage, and it was felt that it was in the broader public interest that he be dealt with through the social care system or social work system and given intensive support, family support and other things, rather than potentially at the age of 12 given a criminal record for rape in circumstances where it was extremely unclear as to whether he had any real understanding of what sex even was.
So you're saying that he quite clearly had some other problems. He clearly had difficulties.
He was emotionally withdrawn. He'd been through some difficult and abusive circumstances in his home life. And, you know, the absolute last thing in the world that you should be doing with a damaged child like that is criminalising him for a serious sexual offence. Because the one thing, and this is the whole theme of the chapter in the book, which is why we should never criminalise children, or why children never criminals, it's called the chapter, is that when you criminalise a child, it's you, i.e. society, i.e. us, who makes that child a criminal for life. Because the criminalisation of itself, just going through the criminal process, is what makes them inextricably criminogenic in their behaviour patterns. Because if you think about it, where is a 12-year-old with a rape conviction ever going to end up in life? I mean, you know, the idea that you can take a child, put them in the Crown Court, have a jury say you're guilty of rape, send them to some form of institution, and that they at some stage are going to emerge from all of that and potentially get a job in a bank or something. I mean, it's ridiculous. And it's extremely damaging, not only to the individual young people involved, but more importantly, in some ways, I guess, from the public's perspective, it just means that they're much more likely to go and commit more and more crimes against more and more victims.
You're just confirming them on the track that they've slipped into.
Well, I'm not sure. I'm not sure that in many cases they've even slipped into a track. I think often they just don't have the maturity or the capacity to understand the consequences of actions, the seriousness of actions, and we used to have a presumption that anyone under 14 was incapable of crime. That was abolished for political reasons after various very tragic but extremely unusual cases of young people being involved in serious offences, including, of course, the Jamie Bulger case and so on. And so we then abolished that presumption, and now there is no presumption, and the assumption is that all children, including 10-year-olds, are capable of appreciating, and forming criminal intent and having all of the other elements of of criminal offending which apply to an adult, which anyone who knows anything about children, and you don't even have to have children of your own, but just using a bit of common sense, will know that a 10-year-old does not have the wherewithal to understand or appreciate the consequences of actions. You know, if they push a boy at the top of the stairs, they're not thinking that he might tumble down, crack his skull open, have a brain hemorrhage and bleed to death. They're not, because children don't appreciate things in the same way. They don't appreciate consequence and cause and effect. And so the way in which you deal with children is who do commit acts which would otherwise be criminal in the case of an adult, is you look at it in two different ways. And one of them is if a child represents a risk to others, as some do. And in my experience, a very, very tiny percentage of children in the criminal justice system represent an ongoing risk of harm to others. But where they do, and where they represent an immediate risk of that kind, then of course there has to be some security to their environment. They have to be in a secure educational environment, in my view. But in the great majority of cases, children don't represent a risk to others, even where they have transgressed what would be the criminal law. And what they actually need is just to have our sort of the arms of society wrapped around them with education, with welfare support, with family support, and all the other things that perhaps some of us take for granted, because we were lucky enough to get them from our parents and our sort of wider families. But many of these children I'm talking about who are in the criminal justice system are also in the care system.
Yeah.
And so they don't have those sorts of networks and
but they're in support. I mean, the reason why I use the word kind of on a track is because the work that we were doing with the families that we were assessing here was mainly with babies, up to 3 or 4 months. There were a few older toddlers, but we were assessing the potential for these parents to be able to look after their children. And we could see over a period of 2 or 3 months of looking at the care that child had, the way in which the interactions damaged that child from so early on. So they do start to be on a path, and I'm not sure that, I'm sure it's not a coincidence that so many children that you might encounter have been in care, because of course they have been removed from harmful parenting. Sometimes it's worse if they haven't been removed from harmful parenting, of course. But they are on a bit of a track, and the question would be, when do you intervene? Because by the time they're 10, a lot has happened to them.
That's a very interesting analysis, and I think when you look at one of the stats in the book that I talk about, which I think is probably one of the most shocking here, is that if you have been in the care system, you are 14 times more likely to go to prison than if you haven't. Now, that's really quite extraordinary. Now, of course, I fully take on board what you say. Well, that's not just because they've been sort of messed up by the care system. It's because there were circumstances.
Something happened before that,
desperately, cause all sorts of impacts on them, which the care system is trying to kind of help them through, but unfortunately can't. For me, I look at it in a very straightforward way, which is that, children are the responsibility of all of us. They're the responsibility of our society. So when I hear people say, well, what about the parents? Well, I answer, well, what if they don't have any parents? Or what if their parents are incapable of looking after them? Does that mean that we as a society that sort of wash our hands and say we have no responsibility? and anyone that believes that, really, I wonder if they are looking at things in a very civilized or even sort of decent way. So my philosophy about children is that all of us are responsible. If a child's in the middle of the road in danger of being run over, it doesn't matter whose child it is, you as an adult have the obligation, in my view, to try and to lift them up and put them back to safety on the pavement. And I don't think it's any different when it comes to children who have suffered the most horrendous abuse or other forms of neglect in their early years, including, as you say, when they're even newborns. We as a society have to step in, and we have to provide adequate resources to give them the equivalent caring that we give or we receive if we're lucky enough to have parents who are capable of delivering the entire range of parental responsibilities: financial, emotional, educational, welfare, all of the other things that a good set of parents gives to their children. we as a society have to do our best to replicate that for those children who don't have those parental advantages. So that does mean we need to massively and much more greatly invest in services for children. We have to get away from this mentality that, you know, that somehow because their parents are at fault or neglected them, that they are not worthy of the same level of support and care and love, for that matter, that other children are entitled to and receive from their families and their parents. And I think once you start looking at it like that, you realise that the idea of taking a 10-year-old in a police station and putting them in a court, nearly every 10-year-old who's ever been brought into a police station under arrest or accused of stealing or committing some sort of crime, there will always be some factor in their background or lives which means that they are in need of more care rather than more punishment, because children don't transgress. Where very, very few children, 10-year-old children from so-called good families and good homes end up in court, and the many, I'm afraid, from the care system do. And so for me, the focus should be on improving the care system so that there is a much higher level of support and welfare support, and indeed much more careful thought about where children in the care system are. Because I know that you get a lot of children absconding from care and disappearing onto the streets and so on. Well, if a 10-year-old child from a sort of middle class family in Cheshire or somewhere were to disappear, the police would be out in their hundreds, and there would be a huge media campaign about it. But sadly, when children in the care system disappear into homelessness and onto the streets and sex work and so on, very little happens often. I'm not saying that nothing ever happens, but
it is very difficult for people in the care system to take on the role of parents, because, I mean, if you have your own child heading for the front door, heading out into the street, running away, you would go after them and stop them. But you'll hear from people running children's homes that they have rules which says you can't lock the door, you can't lay your hands on the child, and there's tremendous confusion about the level of responsibility we should take for these children, rather than let them ruin themselves, as it were, because they're driven by childish impulses, to actually take on that parental role. And as you say, society has a duty, but it's not really exercised with vigour.
Of course, we all know that there have been so many tragic cases of abuse within the care system by staff and management over the years. Some of which I was involved in the recent child sex abuse inquiry, which was looking into abuse in children's homes over the years. And so sadly there is that history, and sadly there are still examples now of if you think about it, if you are that way inclined as an adult, towards children to abuse them in one way, shape or form, sadly you may well gravitate towards trying to get a job in the care system, and and over the years, sadly, many paedophiles and other abusers have done so, and that's one of the great sort of tragedies of our society and of our history. If certainly up there in the top 3 or 4, I would say, of the things of which we should be most ashamed, that we've provided these environments for children, and sadly we weren't able to protect them even there. But I think you make a good point, which is that we have to have a really grown-up conversation and a grown-up sort of policy agenda around how do you replicate the good things about having a stable parental home life in the care system. The fact that ultimately, as a parent, I'm a parent of children, and the fact that we can take action immediately and urgently to protect the welfare of our children, if necessary, as you say, by picking them up and stopping them, running across the road or leaving the house or whatever, and at a young enough age anyway. And how do you protect staff who are good quality staff, who have good intentions, who have to do the same sorts of things in respect of the young children in their care? There has to be protection, but there also, of course, has to be a means of monitoring and ensuring that it doesn't become a recipe for abuse.
Yes, of course.
In a number of cases. So I'm not pretending it's, and it don't, principally my area, as you know, is criminal justice, but rather than care and the care system itself. So I kind of see it after the system has failed.
Well, you're sweeping up some of the problems, aren't you, and trying to find solutions, which are less harmful.
And as a parent, I just look at it. I look at all the advantages that my children, and indeed I had as a child, growing up with really loving parents. And I look at that, and I just think, there must be some means by which we can provide as close as possible a replication of that for all the children in our society. It's about resources, it's about diet, it's about exercise, it's about all of the things that good parents encourage their children to eat well, to exercise, to educate, to be educated, and to engage with their education. And we just have to find some way, and of course, to give them emotional support on a daily basis, and pick them up when they're miserable, and so on. How do we replicate that? Now, I'm not an expert on that, but I know that's what we need to do.
Well, I think there must be allies throughout society where people responsible at different levels of different age groups and with different resources who need to get organised really and produce some coherent approach.
Well, they're also they can be very hard to help these children, because as well as doing care proceedings, I was also doing secure accommodation proceedings, and I only ever dealt with girls actually in those applications, which meant you were there representing them. They are difficult to help because they don't trust anybody. They don't think you're going to help them. Their experiences are really awful, and nobody's loved them, nobody's helped them. And so why would you, coming into this room saying, look, I'm here to help you, take any notice? And actually this coincides with something that we've also been tackling or hearing about recently, where we've just interviewed somebody who works at Whitemoor in the FENS project, or FENS programme. She led or leads that programme, and she's saying that these are men who are seriously dangerous psychopaths. They're lifers, they're unlikely to be released, and they get sent, they are in this programme. And what they most hate is any care and attention, and that's what destabilises them. Not
is when people start being nice to them.
Not shut up and move, or if you don't, we're going to carry you and we're going to get the kitted men out and you're going to be moved. They can cope with all that. But as soon as
that's what they've been conditioned to.
That's what they're used to.
Absolutely, and it just it just made me think when you were talking, these children are just as difficult because they don't trust. And somebody's got to do that difficult work. And this woman is saying, really difficult to work with these people. They're going to try and, undermine everything you do. They don't believe that you're there to help them. They believe that you're actually there to do the opposite. Gradually, after about 3 years, this is a 5-year programme. She says after about 3 years, you see huge transformations, and it must be wonderful to see. But you've got to go through, as a therapist, as a person dealing with them, even the prison officers have to go through this process of really difficult, challenging, not dangerous necessarily, but really difficult, challenging conversations where you're not really going to get where you want to get. You have to keep going back. You keep staying calm.
This overlaps with what you've written about prisons, doesn't it?
Yeah.
Because clearly the experience of these men is of control and restraint and a violent atmosphere in prison, which simply perpetuates the damage they've already experienced. They're comfortable with it because they've lived with it since they were children. And so there's this theme of what happens to children and what happens in prisons is all part of the same story.
Well,
isn't
it is, and hence my kind of final chapter is, why people are neither good nor evil. And I'm looking at I'm trying to, in the book, trying to join up what I consider to be the 3 major policy areas. That's the overuse of prison, the prohibition of drugs, and of course many of these young people are already addicted to drugs of one kind or another before they're even from the age of 10 or even younger. So none of these sort of fundamental issues exist in isolation. So you end up with young people, often in the care system in particular, becoming addicted to drugs. That of itself leads them to become embroiled in the criminal justice system. That leads them before too long into the youth justice and then the young offenders institutions. And then before long, they graduate to prisons, which, of course, then, as you say, reinforce all of that negative messaging and all of those negative lifestyles once again, and institutionalize and condition them to a life of being a revolving door in and out of custody. And nobody really cares. But it's very interesting. You talked about that program. I say nobody, that's not true, but most sort of the average voter, if you like, really doesn't see the welfare of those who have entered the criminal justice system, even if they are children, as being a particular priority for our society.
No.
And so when you talk about the sorts of programs that you just mentioned for some of the most dangerous individuals or those who have committed what are intrinsically the most serious and awful of crimes, many people would just say, well, who cares? Just put them in solitary until they die.
Yeah, forget them. Yeah.
Doesn't matter. Just lock them up.
But of course, they're costing a fortune.
Problem solved.
They're costing a fortune,
That's true.
And before they've
say, well, why are we spending all that money on just give them some bread and water, and hopefully they won't last long. Which is I have to say, if a politician were to come out and say that, you wouldn't have it wouldn't be a vote loser.
No, and that is very frightening, isn't it?
Well, it is. That's the saddest thing of all, and that's why I tried to sort of bring all of those different policy areas together, because people assume that people in prison are bad people, are evil, when actually most of them are deeply traumatized and damaged individuals,
they are.
Often with histories of serious psychological and mental health problems, and of course abuse and being in the care system. So nothing's binary. It's not simple. It's not them and us. And likewise, those who are who take drugs either because of addiction or otherwise are not bad, evil, terrible people. And the children who transgress are not bad or evil people, and there are plenty of sort of so-called respectable and decent and kind and people out there who do appalling things. So judge actions for what they are, which is actions, and look to try and reduce the number of harmful actions in our society, rather than just labelling people as we do as either good or evil, and therefore condemning. Or approving, depending on which camp they fall into, because the world doesn't work that way. No. It really doesn't. Many crimes are committed by people who were hitherto very good people, and many people, I described the London Bridge attacks in the book, which were committed by someone who'd been released from prison. But two of the men who came to try and protect those who were being attacked were themselves they were on licence for murder. On life license for murder, and on in one case I think on day release. So you've got people who have been convicted of murder, have spent a long time in prison, who are willing selflessly to walk into danger to try and protect others. But we always assume that that people are only all good or all bad, and the truth of it is none of us can look ourselves in the mirror and say we are all good. And I don't think anyone really should ever be forced to look in the mirror and say I'm all bad. People commit terrible acts, but the most terrible acts are usually, in my experience, related in some way to either early trauma and the impact of that trauma, or to some abiding personality disorder or psychiatric illness. And neither of those things are things that are chosen.
Well, personality disorders come from somewhere. Children aren't born with personality disorders. They
Exactly.
develop them as a way of coping with the experiences they have, and then that makes them a burden to society later in their lives. So you've written the book. You're talking to people about the book. What happens next, though, Chris? How do things change?
Well,
do you have a role in that, or are you?
I don't have any role in the sense of I have no aspiration towards sort of political office or anything like that, because frankly I'm not sure that many politicians have much power to affect change. I mean, I was very interested when I was doing some research for the book in Switzerland. I interviewed politicians and senior prosecutors and even very senior police officers about the drug issues in Switzerland and why they'd moved from a system of really quite sort of draconian prohibition to a system of heroin-assisted treatment and a much more pragmatic approach to drug policy generally. And that had led to an enormous reduction in violent crime related to drugs, and most importantly, perhaps, had led to an enormous reduction in drug overdose, to the point where in Geneva that hardly ever happens because of the facilities that are available, and because of the compassionate way in which heroin projects are run over in Switzerland. And I was very interested because you kind of would assume that it would have taken a sort of charismatic politician to persuade people to kind of go along with this. But actually what happened was, Switzerland, as you may know, is a country which is based on referenda. Almost everything is decided directly by direct democracy in votes. You know, if you want to move a dustbin from one end of the street to the other, you know, you have to have a little mini referendum on it, and everyone gets to vote. And they have town hall meetings, and they vote on literally everything. So they have hundreds and hundreds of referenda on all sorts of things, from local level up to federal and then national level. And the way in which the drug policy in Switzerland developed was actually, it grew organically from demands in communities to remove heroin use, needles and heroin users and drug dealers from areas which were impacting negatively on children and people going about their business. So, you know, you had railway stations full of people shooting up heroin with dirty needles, which were then left lying around. You had public parks full of them. And so the public gradually began to say, what, how do we stop all of this? How do we get rid of all this? And the answer wasn't, well, we give them all life sentences and we crack down on them all. The answer is, we look at how we remove the health issues, how we remove the supply chain problems. So obviously heroin users who have to buy for the illegal market have to commit crime, or they have to become involved in sex work. So they remove all of those drivers for the criminality by giving them heroin in clinics with clean needles and medical support and everything else. And the public, just over a 20-year period, went from very, very anti-drugs and let's have crackdowns, which is the mindset in most countries, frankly, to a situation where the public were prepared to endorse heroin-assisted treatment across the whole nation in a federal, in a national referendum. And so it was driven not by a politician saying this is a good idea and people buying into it. It was driven by the evidence of what worked in community, and people suddenly realising there are no more needles in the parks. Well, that's good. Why not? That's because they're using clean ones in the heroin-assisted treatment place, and they're going into needle bins. And so the needles are not floating around in society anymore. And, you know, and our children can play on the swings because there's not going to be someone passed out underneath the swings from a heroin overdose. So I think that idea that you can get some enlightened politicians who are prepared to allow experiments to take place, but you then just prove the model. You prove what works in small ways, and then communities will say, wow, our community is so much improved by what we've changed. Other communities down the road will say, well, hold on a minute, we want to be like that. We don't want to have the burglaries that we have.
So a better informed public, really.
Yeah, it's all about information, and it's all about, you know, I mean, your question about whether, you know, what happens next and how do you achieve reform. I have to say, in the UK and certainly the US, where I also travelled and write about extensively in the book, my kind of level of optimism is very low. Because I just feel that the political debate in the country has become about the lowest common denominator in terms of, particularly when it comes to crime and justice policy. It's about who can appeal to that sort of guttural instinct to kind of punish and get revenge and crack down. And so we have a Home Secretary in the form of Priti Patel and a Prime Minister in the form of Boris Johnson, who went into the last election in 2019 campaigning on a platform of sending people to prison for long,
tough on crime,
cracking down even more on drugs, and absolutely nothing coming out of the policy making at Westminster, which looks remotely pragmatic or positive from my point of view. We get it. We are increasing the length of time that people spend in prison, even though it's already doubled our prison population in the last 25 years. And the political direction of travel in the UK and the US, which are the two countries which I'm most familiar and know the most about, I'm afraid is the exact opposite direction to the one that I would like to see. We are seeing no movement on drug policy. We're seeing no movement on the use of prison. Well, we're seeing them in the wrong direction. And we still get the rhetoric about, you know, feral children and all the other stuff that politicians say come election time, and, you know, out of control and the parents are to blame and all the other stuff. that we get, and I'm afraid that narrative is just as prevalent, if not more prevalent now than it was 20 years ago, or 30 or 50 years ago. So
what a
I
shame.
see absolutely no light at the end of the tunnel as far as criminal justice or social policy involving those core areas of drugs, prison, and children.
So things have to get worse, really, so that the public get to a point where they look at places like Switzerland and say, well, why not here? Why,
Possibly.
But you can't prescribe worse. You can't say, let's make it worse.
Well, we are making it worse. That's my
Yes,
point.
but as a way of trying to make it better,
No, and it
that's
doesn't
no
work
way
anyway,
forward.
Because
Yeah.
you take it to its ultimate conclusion, and you get to the United States with 2.3, 2.4 million people in prison.
They've shown where it goes.
Let's not.
Tens and tens of thousands dying of drug overdoses every day, tens and tens of thousands being murdered every year. And, when you have a society like the United States, and we look across the Atlantic, they speak roughly the same language as us, so they have many of the same legal processes and systems as us, and they've made such a monumental set of mistakes.
And they can't say it's safer, can they? They can't say it's a safer country.
It's not remotely safer. It's one of the most dangerous places on earth, despite being the wealthiest country in the world, despite having 16 or whatever it is of the best universities in the world in one country. They have the most extraordinary excellence in the United States in many, many areas of their life, from the arts to education to business and industry and all the rest of it. But when it comes to sort of crime and social policy, they are like something out of the sort of 16th century. And much of the mindset derived from that early period of American kind of colonization, where it was all very much about crime, punishment, and retribution, and the Old Testament, and that still guides much of their policy. So they can create these amazing sort of industries like Apple, and could create these amazing devices that can do all sorts of things. But what they can't do is stop half of the black population in some cities being in prison at any one time. And it's just quite extraordinary to me. But we're not learning the lesson, because our politicians are spouting the same hackneyed, dangerous nonsense that they spout in the United States every election cycle.
Well, we're going to do as much as we can to promote the book so that people at least read the arguments and form their own opinions. And it's brilliant to hear from somebody who sits somewhere in the establishment, but kind of not a comfortable fit by the sound of it sometimes. And
I think there are always radical sort of lawyers. I'm not actually a sort of politically left wing or radical in particular.
No.
I'm an arch pragmatist, and I've spent nearly 3 decades working in a system that is fundamentally unfit for purpose. And if people want to read about just why that is the case, they can read the book. Hopefully, it's not just a rant, as you know. I mean, it isn't. I
think it's great.
Some humour in there, and there's some stories about some of the cases I've done over the years.
Yeah.
Some are very sad. Others, there are elements of humour in the legal system, which I hope come across. But listen, if one or two people speak to another one or two people and say, do you know what, maybe when I kind of say that lock them up and throw away the key, and maybe when I sort of go on and on about drug use and kids and teenagers being a nuisance on the streets, maybe there's another side to it. Well, that's job done.
Thank you for giving us your time.
Yes.
It's very kind of you and very interesting.
Do talk to us again. I hope you will anyway.
Sure.
Thank you.
Thank you so much. I appreciate you having me on.